Make a statement of desires. This is not a legally binding document, but gives valuable information and guidance to your executor. It should include the information needed to clearly identify and locate all of your most important documents. It should include contact information for relatives and close friends to be notified of your death, where assets are located, and instructions regarding your desires for burial, cremation, funeral ceremonies, organ donation, and the like. Stay tuned for our next blog pod, and in the meantime, if you'd like to find out more about estate planning, please feel free to visit our website at ericapplellaw.com, where you can learn more, give us a call, or drop us a note. Until next time, thank you for joining us here. Please like, subscribe, and share so we can help you and your loved ones become more informed and we can work together to live more powerfully into the future. Hello, and welcome to another edition of the Eric Apple Law Blogpod. Today, we're talking about a checklist for estate planning. Everyone needs some degree of estate planning, and such plans need to be tailored to the needs of the individual. This estate plan checklist will help explain the different kinds of planning documents and help you decide which of those you think you need. A comprehensive estate plan should take into consideration what you'd want to happen to your property upon your passing, the financial well-being of your family, and how to eliminate or minimize estate taxes. In addition to financial matters, an estate planning checklist should also consider the guardianship of any minor children and medical treatment planning. Any asset that has title documents, such as real estate and motor vehicles, can be set up so that upon your death, the title automatically passes to a co-owner, most often a spouse. The title documents must indicate clearly that ownership is held as joint tenants with right of survivorship. There are two potential cons in adding someone as a joint owner. First, you will need the joint owner to agree to any loans secured by the property. Second, if the value of the property exceeds a certain amount, it could trigger the federal gift tax. For some assets, you can designate someone to receive the property upon your death without giving them current ownership rights. This is often done with financial accounts, usually called pay on death or POD. Designating a beneficiary is available in almost all states for brokerage accounts, and in some states for real estate, motor vehicles, and other assets with title documents, usually called transfer on death or TOD. Cover your debts. One way to ensure that all your debts, including burial expenses, are paid in the event of death or disability and that your loved ones are provided for is through auto, homeowners, disability, and life insurance. Create a last will and testament. A last will and testament handles any property that must be probated. A will can also cover the care of any minor children or adult children with disabilities. You are in charge of designating who will get any property that hasn't been handled through joint ownership or a beneficiary designation. Appoint someone you trust as the executor of your estate, and appoint someone you trust to be the guardian or conservator of your minor or disabled children. Create a living trust. Especially if you have a large estate or many beneficiaries, a revocable living trust is usually the best choice for handling property distribution, trying to avoid probate, and minimizing estate taxes. The property title is transferred from you to the living trust, and you become the trustee. While you're still alive, you control the property. You manage the property as if it was still yours in your name, and if you want, you can acquire more property and add it to the trust. Upon death, the person you appointed as your successor trustee assures that the property is transferred to your trust beneficiaries. The successor trustee would also manage the trust if you become mentally incapacitated. Name a financial power of attorney. A financial power of attorney authorizes someone you trust to act on your behalf in financial matters. Depending on how it is worded, a power of attorney can either be effective immediately or upon the occurrence of a future event. If effective immediately, your agent may act even if you are available and not incapacitated. The authority conferred by a power of attorney always ends upon the death of the principal. Name a healthcare power of attorney. A healthcare power of attorney designates someone you trust to make decisions regarding your healthcare in the event you are mentally or physically unable to make decisions for yourself. Create a living will. A living will, also known as advance directives, sets forth your wishes regarding what types of life-prolonging medical treatment you do or do not want in the event you are unable to communicate your wishes. A living will goes along with a healthcare power of attorney as it can serve as a guide to your agent or can express your wishes in the event your agent is unavailable at a crucial moment.